I'd like to give a brief history behind this wage codes. The Constitution consists of 470 articles 20, in 25 parts, and it has got 12 schedules. In seventh schedule, there are three lists. One is central government. That means the powers central government will have to enact laws with regard to taxes, defense, foreign affairs, etc. and etc. And the second list contains state government powers to enact laws with regard to education, health, etc. There is another list called concurrent list, in which both central government and state governments will have powers to enact. So this is where our labor codes are going to get into. So we have about 100 plus state labor laws and 40 plus central labor laws before these enactments. So the first National Commission on Labor started way back in 1969. And after that, the second National Commission on Labor uh, commissioned in 2002 under the prime ministership of Atal Bihari Vajpayee. You can understand, if you see the act the year of passing of the act will itself say that, it was way back about 40 years, 50 years, 60 years. Some acts were enacted well before the independence also. So they need to be reformed or changed uh, to meet the current demand or requirement with regard to labor requirements or employers requirement or needs. So based on the recommendation of Second Labour Commission in 2000, it was set up in 1999, but they have given their recommendation in 2002 that there is a need to change all these, age-old laws or summarize these laws into one. Otherwise, what is happening? Take the example of simple wage definition. The wage definition is, like one model in one act, another model in another act. So it gives a lot of confusion, and because of which the implementation also becomes very, very difficult. So under the Prime Ministership of Sri Atal Bihari Vajpayee, it was set up in 1999. In 2002, this National Commission has given its recommendation, but after a lot of discussion, deliberation with unions, employers, federations, FICCI, FAPKIs of the world. So after all this deliberation, they have come out with this wage codes, four wage codes in 2009, 2019, September 2019, and 2020, all four acts were passed. The main objectives of the act is behind these acts is ease of doing business, especially after we have opened our gates for the globalization. So behind the scene, that is ease of doing business is there. Uh, Basically to bring in simplicity and avoid multiplicity of various laws. Actually, the Second Commission on Labor has recommended 40 plus laws to be merged, whereas in these labor codes, they have merged or subsumed only 29 acts to facilitate ease of compliance. Because of this various definition in various acts, even the labor departments were finding it difficult to implement these laws. So what happens? They will take advantage of that. They will try to, bargain with the employers and gain their personal benefits instead of implementing it fully. So ultimately, to achieve equity and, for all and facilitate employment growth while protecting workers' rights. Otherwise, when you merge all these things and try to do something only for the employer, workers will protect. If you try to do for workers, employers will object. So it was a balancing act to some extent they have done. I don't say it is 100%, but it is a first step towards reforming these age-old laws. Ensure effective enforcement is another objective of this, and better technology, use of better technology by way of electronic licensing system and verification of records through technology. PF authorities, ESI authorities, no need to run around their offices nowadays. Even your transfers, withdrawals, everything is online by merging your Aadhaar card or updating your Aadhaar card details. So these there are four labor codes comprising of 29 acts. First one is Code on Wages, and the second one is Code on Social Security. Third one is Industrial Relations Code, and the fourth one, as the name suggests, Occupational Safety, Health and Working Conditions Code, 2020. Let's get into each code and see what are the changes that they have attempted to bring in. The Code on Wages Act 2019, introduced in Lok Sabha and was passed on 30th July 2019. The effective date for this GO has come only for this code. Effective date is 18/12/2020. Like I mentioned in the previous slide, this is a concurrent list act. That is the reason why it is still pending. Everyone is expecting that from 1st April, these things will come into effect. But I am afraid so far there is no GO from any of the states in India. No state has come out and then they have formed any rules and regulations to implement these acts. The central government has issued the GO effective December, but so far no state government has come out. The Code on Wages 2019 is an amalgamation of 4 labor laws relating to wages and bonus. It subsumes the Payment of Wages Act, Minimum Wages Act, Equal Remuneration Act, and Payment of Bonus Act. All these acts are now coming under purview of Code on Wages 2019. This is the only act which was passed successfully in 2019. Balance 3 acts were passed in 2020. The first thing is it is applicable to all sectors. If you all remember, most of you from HR background, so you all know that we used to have scheduled employments, various schedules like hospital industry, hotel industry, sugar industry, like that, various industries under that each minimum wages they used to give GOs. Now it is common. They have merged all those things and they said it is applicable to all sectors, including unorganized sector. There is no bifurcation now. So another important thing in this Code on Wages is floor minimum wage. They brought the concept of floor minimum wage. That means what? Central government will declare a floor minimum wage, which has to be implemented across the country. But state governments are given powers to notify their own minimum wages depending on the cost of living of that particular state. So they will have the power to notify minimum wages over and above the floor minimum wage. They cannot declare below minimum wage. If you all can recollect, once upon a time, the Odisha, Chhattisgarh, we used to have the lowest minimum wage in the country. Kindly mute your mics, please. So the state governments were given the power to notify minimum wage over and above floor wage, but not lesser than the floor wage. That is a very, very important decision in this Code on Wages. Another thing is earlier the claim for any pending wages, workers can make a claim to the organization within 6 months. But now they have increased this span to 3 years. So if you have closed or changed any contractor, please keep your records for at least 3 years. Workers can anytime come within those 3 years now after implementation of this act and claim their pending wages or unsettled, full and final settlements. So this is another important thing. The bonus eligibility, there is again a confusion in this. Previous amendment also there was some confusion with regard to whether it has to be paid on 7,000 rupees threshold limit or on the minimum wage, whichever is higher. That was the act. But then many organizations have paid only on 7,000 rupees. And the limit was standard 21,000 across the country. Now, in this act, what they have done, they have declared that bonus has to be paid, and state governments are authorized to declare whatever is the threshold limit of 21,000. So Andhra Pradesh may declare 25,000, Telangana may declare 30,000. It is left to them. So if for the companies which are going to operate in various states, we cannot take 21,000 and then calculate the bonus. It is going to be further complicated. So each state, whatever they are going to declare, based on that, we have to calculate this bonus. So this is another important change that they have brought in. All employees are protected without any wage limit, including supervisors and managers. Earlier, it used to apply only for people who are drawing less than 24,000 rupees. But now in this Code of Wages, they have removed that threshold limit of 24,000 rupees and said everyone is eligible. for this. Applicability of the wage code applies to everyone. The year used to be different years, but now they have said only 1 year, April 1st to 31st March. That is common for all the states, and there is no permission to change this with respect to their faith or state. No chance now. Disqualification of bonus, there is another important amendment they brought in. Earlier, all misconducts were there for making a person disqualify for payment of bonus. Now they have added additional provision under this for conviction of sexual harassment. In case a person is, convicted for sexual harassment by the committee, internal complaints committee, all of you must be aware, and you must have the committee in place in your organization. So in case someone is convicted for this, he is disqualified totally for the payment of bonus act. This is another additional thing they have added for the disqualification. Mode of payment, earlier bonus we used to pay, some companies used to pay by way of cash, but now they have barred that. Now payment has to be done only through bank account. Only through bank account. There is no payment of cash bonus. Not possible. And whenever there is a dispute with regard to the payment of bonus, whether it is 8.33 or 20%, earlier unions used to demand you pay 20% and adjust it later on. Now it is not there. Now they have made it very clear, if there is a dispute in the tribunal, organizations can pay 8.33%. Once it is decided in the tribunal, they can pay the higher bonus, but not before. So organization can now safely pay 8.33%, and then when the tribunal gives its judgment, they will pay as per the judgment. Earlier, this kind of provision was not there, so unions used to demand payment of early high bonus from the organizations. This is again another important rule they have put in. Yeah, another thing that they brought in this code on wages is gender discrimination. Earlier, gender discrimination clause was there only in Equal Remuneration Act, whereas in this they brought in and included recruitments, transfers, promotions, all kinds of recruitment processes and career progression processes are brought under gender discrimination. So whether fixation of wage or transfer or recruitment, promotion, anything, there should not be any gender discrimination. And earlier in the previous acts, territorial jurisdiction was there for inspectors and officers of the labor department. Now they have removed. So earlier organizations used to have some kind of agreement with the regular officer so that he will not come and inspect. So even if he comes, he used to manage. All those things are not possible now. What they have done, they have made it computerized. So by through a computer program, the organization will get allotted to a particular officer. So we don't know who is going to come, and whoever is going to come and inspect, within 48 hours he has to update his inspection status report onto the online website of that particular department, whether it is labor department or PF or ESI. Whoever comes for inspection, they have to update in their website about their inspection. So we have to be very, very careful with regard to the compliance framework in our organizations. Earlier, we used to maintain more than 10 registers and 4 returns. Now they have simplified what they have to maintain. Only 2 registers are required to be maintained. One is employers register and the other one is wages register. Earlier, we used to maintain fines register, deductions register. All those things are not required now. The second important thing is code on social security. This code on social security has got 9 acts into this. One is the Employed Provident Fund Act, ESI Act, Unorganized Workers Social Security Act, and then Cine Workers Act, Payment of Gratuity Act, Maternity Benefit, Employee Compensation, Employment Exchanges. All these things are brought under this second act of Code on Wages Social Security. GO is yet to be released by central government. So once the GO is released by central government, then state governments will start enacting rules and regulations to implement this. The first major thing they have done is earlier we used to register our organizations differently. Say for example, PF registration is different, ESI is different, building and construction, different licenses we used to apply. But then now they have made it very simple, and only one registration is sufficient under all these acts. And they have also formed a National Social Security Board and State Unorganized Workers Board as per Section 6. Earlier, it was not there. Actually, as per the second National Commission recommendation, they were supposed to merge both PF and ESI, but they have not done that because of various objections raised by the unions of PF and ESI departments. So, but then they are trying to bring in some National Security Board and State Unorganized Workers Board. For this also, there is no GO issued till date. So we await some clarity on this as to what are their powers, what they are going to do, not clear. Again, appeal against Provident Fund. This is another important thing. Wherever any organization has got any dispute, earlier PF department used to send challans and then asking us to pay 50%, 70% excess amount than the amount paid. Even the court, if you want to go and fight the excess amount claimed by the organization, courts used to ask us minimum 50% to 75% deposit the amount, and then only the court case used to progress. But now they have reduced that amount to 25, making it easy for organizations to pay and fight out the excess demand made by EPF authority. This is another important change that they brought. And ESI, notional accident or notional in the course of employment injuries, that they have extended now. They have extended it to traveling in any vehicle with permission of employer, also covered in this act. Earlier, that was not there. If he is going by his own vehicle or somewhere, if he is going, it was not covered. But then to protect the workers who are on the job, and especially with the permission of employer, if he goes by a different transport than the regular one, he is covered under notional accident while in service or during the course of employment. Expenditure incurred upon employee who was not insured in time. Many times what happens, employee joins, but organizations do not cover them from day one, especially ESI. So for such things, heavy penalties have been imposed. And in case of any sanitization not up to the mark, insanitary working conditions, if it is there, if someone complains to the organization, that extra expenditure has to be paid by the organization. Important thing in this code on social security is protection for gig workers or platform workers. I hope all of you are aware of these gig workers and platform workers. For example, this Zomato, Swiggy, all these people, Rapido, your Uber, Ola, all these people come under gig worker or platform worker category. So the central government is trying to bring in all these welfare facilities to these workers who are working in gig workers. If you have seen the recent research on these gig workers, earlier it used to be less than 5%. After the COVID, it has increased more than 15%. So the future is going to be the kind of employments are going to be based on this gig worker model or platform worker model or fixed term employment model. So the challenge is how to take care of these people, because you are not sure whether they are employed with you alone. Say for example, Uber driver, the same driver, if you ask him, he'll say, I am there on Ola also, sir. So how to take care of his welfare benefits? He is working simultaneously with 3-4 employers. That is going to be a challenge. Even with regard to the social security measures for these people, clear-cut guidelines are awaited. So once they are released, we will come to know how to take care of them. Also, central government wants to fund these welfare measures to be taken up by the state governments partly. So that partly, whether it is going to be 20%, 30%, or based on the number of people, or based on some wage criteria, that is also not clear. A welfare scheme, like I mentioned, welfare schemes by central government for unorganized these gig workers the proposal includes life and disability cover, health and maternity benefit, old age protection, education, benefits as may be determined by the central government or state government, salary. and whatever gratuity, eligibility. So all those things as per the norms you have to pay, and then you can retrench people. But taking permission from government is removed in this code. And another thing, they have excluded fixed term employment after completion of the term, 1 year of term, that is not coming under retrenchment. So automatically that employee has to leave the organization after that particular period. And definition also increased from only worker level category people. They have included now skilled, semi-skilled, unskilled, manual, operational, administrative, technical, all kinds of employees are included into this Industrial Relations Code 2020. Earlier, working journalists were not there. Now they have included working journalists and sales promotion employees also into the definition of worker under this Industrial Relations Code 2020. Organization used to misuse the non-recognition of union. It was not mandatory to recognize any union, whether it is a registered union or unregistered union. Organization used to also encourage their own people to form another union, and then they used to favor decisions in favor of the union they will support indirectly. But now that is not there. Now they are trying to bring all these people under negotiating union and council. Sole negotiate sole negotiating union with 51% of workers. If they are supporting one union, it will become sole negotiating union. Council means if there is no single union, then they have to form negotiating council with all unions. Say, for example, one organization has got 3 or 4 unions. So every union must represent in this council. Whichever union has got more than 20% of workers as members, they will get a membership in the negotiating council, and organizations are mandatorily required to negotiate with this negotiating council. Earlier, these concepts of negotiating council, negotiating unions were not there. Now they have brought in. So workers will have more bargaining power. Collective bargaining will be strengthened because of this amendment in the industrial code. And earlier, the scope for trade union disputes used to be High Court also is there. Now they have removed High Court. They have to go to only tribunal. That way, they have reduced burden on High Court for labor matters. Tribunals will be empowered with 2 more members. Earlier, tribunals used to have only one judicial member. They are going to have 1 more member, but administration member. This I have my own doubt how it is going to help, because the person is going to be administration member in addition to judicial member. If it is judicial member, they can divide the cases. How far administration member going to help the judicial member in clearing the disputes quickly, we have to wait and see. Earlier, re-employment for retrenched person, preference for retrenched person used to be there. Now that is there only for 1 year. After 1 year, no preference. They will lose that preference for re-employment in the same organization. These flash strikes earlier used to happen whenever unions wants to go on strike. They used to go. Now they have put a stop to that by prohibiting flash strikes. Even if organization wants to declare lockout, both sides they said 14 days notice is compulsory. They have to inform union that they are going for lockout, or unions have to inform and give proper notice with charter of demands 14 days in advance to the organization, so that in that 14 days period they can renegotiate, collectively bargain, and mutually beneficial agreement can be arrived. And flash strikes were completely prohibited in this code of social industrial relations. Earlier, this provision was there only for public utility services. Now they have brought in for all private sector also. It is applicable. They have created a reskilling fund in this industrial relations code. 15 days wages, last drawn wages have to be calculated and to be paid whenever we are retrenching an employee, so that the labor department will use that money to reskill these workers who are retrenched. Earlier, this provision was not there. Layoff, retrenchment, like I mentioned, for retrenchment and layoff, earlier the permission to be taken if you have 100 people. Even for layoff also, a temporary layoff also, you need not take permission if your organization has got less than 300 workers. Even the standing orders also applicable only if you have at least 300 workers. If you don't have 300 workers, you need not go for standing orders. You can as well use model standing orders. They are applicable. Compulsory certified standing orders are not required now if organization has got less than 300 workers. Earlier, this provision is not there. Once covered, it continues to be covered. Say, for example, in one particular year, you have 310 employees. After that, it becomes compulsory for you to go for certified standing orders. Next year, you have got only 290 employees. Now you cannot say it is not applicable to you. So you have to continue to use that standing orders to manage the service conditions of the employees working in your organization. So once covered under that act, continues to be covered. The fourth act is Occupational Safety, Health and Working Conditions Code 2020. This is the major code. It has combined about 13 acts into this, like Factories Act, Mines Acts, all big acts, Contract Labor Act, Building and Other Construction Workers Act, Motor Transport Workers Act, Working Journalist, Wages, BD cigarette, all these people, sales promotion, cine workers, all are covered under the Occupational Safety, Health and Working Conditions Code 2020. Registration has become electronically. One registration is sufficient for any of the organization. And we have to issue appointment letter to all the people we are going to employ, whether directly or indirectly. Whenever you are engaging contract labor, please ensure that your contractor gives the appointment letter to your workers. Annual health checkup has become compulsory now. The information related to employees' health, organizations are required to give mandatorily. So annual health checkup as per the act, we have to provide a doctor and then get the people health check. In case of anything, they have to immediately take care of that employee. Central government to constitute the National Occupational Safety and Health Advisory Board. There is no circular or GO forming this health advisory board as of date. So they may be forming in future. So based on that, we'll know what are the powers of that board. Welfare officer, earlier it used to be more than 500 workers. If a factory has got, they have to appoint mandatorily one welfare officer. Now they have reduced it to 250 workers so that the welfare of the employees or workers is taken care, especially in factories, mines and plantation fields. Similarly, safety committee, earlier 1,000 people required. Now for 500 workers itself, you have to appoint a safety committee officers. If it is a hazardous process, chemical industry, hazardous chemical industry, 250 workers, you have to appoint a safety committee officer. If it is a mine, it is 100 people, 100 workers. So they have reduced the limit from 1,000 to 100, 250 and 500, depending on the process industry. If it is a hazardous process, 250. Normal factory, 500. Responsibility of officer or employer increases for maintenance of health, safety and working conditions of the employees on rolls as well as contract labor. Both now it has become the responsibility of the principal employer. Earlier the provision was in case contract labor contractor fails, it used to be the obligation of employer. Now it is directly on the or jointly and severally both contractor and employer are responsible. Another thing they brought in this occupational safety, health and working conditions code is they have increased it to 12 hours, 8 hours to 12 hours. Earlier 12 hours used to be for overtime, 4 hours. Now 12 hours working day is allowed. For generalists, it is maximum 144 hours. Overtime work is allowed with the consent of worker. Annual leave with wages, almost same, 20 days, 1 day leave. Worker entitled to encashed leave above ceiling as prescribed. That provision was not there earlier. Women employees employing them beyond 7 p.m. and before 6 a.m. with consent is allowed in this code now. Earlier, that provision was not there. Now, a woman can be employed in any shift, any field. That discrimination is removed in these codes. Earlier, lot of restrictions on women employment. All those things were removed in these codes now. Another important change they brought in is earlier contractors used to take license every state. Say, for example, organization is giving contract labor agreement to a contractor in 4 states. He used to bring 4 licenses. Now he can apply for all states, one agreement, one license. And earlier that license used to be valid only for 1 year. Now it is valid for 5 years. So running around labor departments has drastically come down because of this online registration, and registration is valid up to 5 years. Welfare facilities to contract labor to be provided by the principal employer and contractor jointly and severally. So we have to be very, very careful with regard to the welfare facilities implemented by the contractor. If workers apprehend there is a likelihood of imminent danger, they can bring it to the notice of the organization, and organization should take immediate corrective action. Otherwise, penalties earlier used to be 2,500 like that. Now all these penalties, please remember, it is in lakhs. So any penalty, it is going to cost your organization. So the compliance has to be very, very strict. Another important thing they have brought in into this is employment of audiovisual workers. There is no such provision taking care of this kind of differently challenged employees, workers rather. So we can register and then register with competent authority. A written agreement can be entered into with these workers, and similar facilities can be provided to suit their challenges. Employment of 18 years below people were not allowed earlier. Now it is allowed in the form of apprentice or trainees. Earlier it was there for apprentices. Now they are making it easy for taking apprentice and trainees under national skill development. Some states like Madhya Pradesh, Uttar Pradesh, Gujarat, they have further reformed. They have further reformed and said establishment up to 100 workers they can hire according to their needs. That means they need not inform government. No registration for contractors up to 50 workers. No inspection for organizations less than 50 workers. Third party inspection also allowed. Same day registration. One time registration, no renewal required for startups. 12-hour shift is allowed. 6 a.m. to 6 a.m. till midnight also allowed. Industries exempted from various labor laws like SEZs. More than SEZs, these three state governments have reformed to attract business into their states. I don't know whether other states are going to take clues from them or further reform to attract industry and improve the employment. We have to wait and see. But these three governments have taken proactive step and further reformed these and labor acts. So after this 4 codes come into implementation stage, what is that we have to do? So I have summarized into 6 action points. One is we have to relook at our compensation structure. If required, we may have to redesign our salary structure. Why? Because they have brought in minimum 50% of CTC should be basic. If that is so, Kameshwar Rao, yeah, I'll just finish in 5 minutes and you can ask your query, Kamesh. Redesign salary structure. In case your salary structure at present is not up to 50% of basic, if it is less than that, if it is more than that, no need to worry. Even if it is more than that, whether you are taking care of gratuity within the gross or within CTC, that you have to relook at it. HR policies may have to change, taking care of the changes in working conditions, leaves, working hours. You have to revisit your HR policies and see if there is any modification required in your HR policies. Payroll, full and final settlements after this codes come into place. Within 2 days, we have to make the payment. Bonus, there will be a change in calculation formulas based on every state. We have to observe what is the threshold limit state government is going to declare. Based on that, we have to calculate all this. So there will be changes in the formulas that we adopt for payroll. Contracts, agreements with contractor, gig workers, platform workers. We have to draft legally binding and applicable contracts with this type of employees, especially fixed term. If you are entering, please ensure that you extend all welfare benefits to these fixed term employees. Compliance, we have to develop robust governance framework. Otherwise, any lapse will attract lakhs and lakhs in the form of fines. And ultimately, this is going to cost organizations, especially if they are on gross model. If they are already on CTC model, it will be less. And if they are on CTC model, and if any organization has got basic less than 50%, it is going to impact both employer and employee. Otherwise, the impact is going to be little less.